Hello, blog readers. A bizarre moment hit the news stream this week as two acting directors showed up to head the government's Consumer Financial Protection Bureau on Monday, also known as the CFPB. Jerry Maatman, partner at Seyfarth Shaw, is here today to explain the situation, discuss the agency's significance for employers, and tell our readers what may happen going forward. Jerry, for those of us who aren't familiar with it, what is the CFPB?
It's a governmental agency that was spawned as a result of the financial meltdown in 2007 and 2008. It was the brainchild of then a Harvard professor, now Massachusetts Senator Elizabeth Warren. And it was designed in theory to be a watchdog organization with respect to banks and corporations dealing with consumer issues. It's been a lightning rod in terms of ideological issues between Republicans and Democrats, and has impacted the debate with respect to class actions and arbitration issues.
On October 24th of this year, the Bureau's arbitration rule was repealed by the U.S. Senate. What was the significance of this action?
Well, it demonstrates that one person can certainly make a difference. The CFPB had promulgated a rule that banned class action waivers and arbitration agreements, primarily in the consumer fraud litigation area. But it was a very broad rule that spiked quite a bit of attention. It found its way to a vote on the Senate floor, and there was a 50-50 tie on October 24th that Vice President Pence, sitting as chair of the U.S. Senate, cast a deciding vote to blow up the rule. It's interesting insofar as it's against a backdrop where the U.S. Supreme Court is considering the validity of workplace class action waivers that are contained in workplace arbitration agreements, the so-called EPIC, Ernst & Young and Murphy Oil decisions or cases that are pending for decision any day now by the U.S. Supreme Court.
On Monday, the CFPB was back in the news when two acting directors showed up to work. What happened here and what was the outcome?
Well, I guess the drama is things you wouldn't even think to make up, but the chair of the CFPB, Richard Cordray, announced his resignation. Many think he's going to run for governor of Ohio. And his outgoing act was to appoint his chief of staff, Leandra English, as the acting head of the CFPB. The White House wanted no part of that, and President Trump himself appointed the Office of Management and Budget Director Mike Mulvaney as the chair or acting chair of the CFPB. Both showed up to work. Ms. English filed a lawsuit in federal court indicating that under applicable law she should take the reins of the agency. However, the court, the U.S. District Court for the District of Columbia, ruled against her. So President Trump's appointed head is now running the CFPB, so one would expect a seismic shift in ideology in terms of the way that agency views its role and how it will interact with corporations and consumers in the future.
Great. Lastly, what do you think the future holds for the CFPB, and are there implications here for class action litigation?
Well, I think here is a area where the Supreme Court and its decision in the upcoming EPIC, Murphy Oil, and E&Y decisions regarding the efficacy of workplace class action arbitration agreements and class action waivers within those agreements will be a driver in terms of policy that will be adopted on an ongoing basis forward. So time will tell, and it will be interesting to see if the Supreme Court should rule against the use of class action waivers in those series of cases, then what the CFPB will do. So certainly put on your seatbelt and stay tuned. We are living in interesting times these days.
Thank you, Jerry. That's it for another interesting vlog from the Seyfarth Shaw Workplace Class Action blog. Make sure to stay tuned to our website and Twitter page as we continue to stay on top of the hottest legal issues.